Okay folks, this is a YouTube channel to help you navigate your way around the UK courts, as well as demystify the law of England and Wales. We're a general litigation law firm. We specialise in cohabitation property disputes, Inheritance Act claims, contested will claims, a little bit of financial mis-selling historically, as well as small claim support and advice. And we do no win, no fee in certain cases. Now, the thing that you need to understand first and foremost is that the Inheritance Act 1975 is there to make financial provision where sufficient financial provision hasn't been made by the deceased. So it's important to bear that in mind, because that's kind of like that informs. There will be a complexity of different types of claims, obviously, and your claim will be unique. But that'll often inform, or nearly always inform, the decision that the court's likely to make. That will especially inform the decision a court is likely to make following the landmark case of Illot and Mitson, which is the only Inheritance Act claim case that went all the way to the Supreme Court, the highest court in the land. So if you are a geek or a law student or something, then read that judgment, because that will give you a good handle on Inheritance Act claims. And that almost could be your nutshell for this vlog, which is basically a daughter, an only child, cut out of a will. Mother left everything to animal charities, and she made a claim. And in the first court, the judge gave her 50 grand. It went all the way to the Court of Appeal. She got 150 grand. And then the Supreme Court overturned the Court of Appeal, and it went back to 50 grand of an estate worth about $500,000. Okay, she was not well heeled. She's not well off. So, you know, even though she wasn't particularly well off, she still only got £50,000 of a $500,000 estate, a bulk of which went to the animal charity. Now that's quite important, because, you know, it kind of reinforces the principle that the deceased, when they make their will, are entitled to do what they want. But obviously that is qualified by whether or not reasonable financial provision has been made. Okay, so, and in this case, the court felt, I mean, she did get something. She got 50,000. So it's not as if she was left completely without anything at all. Now that's just one judgment. In the case of one category of person who can bring an Inheritance Act claim, a child, an adult child in this case, but there are other categories. So let's just go on to quickly have a whistle-stop tour around the other categories. You've got obviously spouse or civil partner, or a former spouse or former civil partner, note, who is not remarried. Okay. You've got the children. As I say, they can be adult children as well as youngsters. You've also got a category of people who are being treated as children, like, you know, foster child, for example, to take an example, by the deceased, and also any dependent, someone who might fall into another category where they're being maintained by the deceased person. Okay. And I should also say there's the category of someone who's been living with the deceased for 2 years, cohabiting. They might not be married. That's a classic situation. There is a romantic partner, they're not yet got married, not decided to get married. You will note, I've just covered all the categories there, but the one category that is missing is a adult sibling, or, well, even a young sibling. So financial provision can't be sought for someone who falls into that category. Now, but, okay, don't forget that the Inheritance Act claim 1975 is just one way of challenging a will where you've been left out, or where there's no will and it looks as if you might be left out, you need to make a claim. There are other, you know, circumstances in which you might be challenging a will. So, for example, I've got a case recently where you've got a sibling challenging the will of her sister, and there's a very good case of what's called promissory estoppel, because they looked after her for quite a long period of time while she was hospitalised, and she promised them a share of the will in return for them offering her all this care. She didn't make any financial contributions to living in my client's home, and they promised her a permanent home. Basically, she died around about in her 80s. So don't forget, there may be another, or you may be challenging the validity of the will. Okay, so there may be other categories that apply. Now, I've just come on to this issue of, what you're likely to get if you bring an Inheritance Act claim. Well, as I say, you've got to look at the criteria of reasonable financial provision, and if they feel that a party hasn't been provided for financially, I mean, a classic example would be someone who's still a child, who's still young, and you've got all the issues around education and looking after that child. There's no other parent. Costs of foster care, for example, which can be very expensive. So that is the criteria that is applied. Reasonable financial provision must be made, and not a bad yardstick, obviously, is what was being done before. One would expect that to continue after death. Now, although that's the yardstick for nearly all of the categories that I've mentioned, where you're a spouse or a civil partner, then actually that's not the yardstick. You probably will get more, because the court will look at, by way of analogy, to compare what you would get, what would be fair if you're divorced. Okay, so in the situations of a former partner or a spouse, civil partner, or former spouse or former civil partner, the court will look, by way of analogy, at what would happen in the case of divorce proceedings. It will use the yardstick in divorce proceedings of fairness, and that's a better yardstick if you're bringing a claim in that category, because you're likely to get more money. The process of bringing a claim is, it's a Part 8 claim. You bring it in the county courts in the usual way. Fortunately, because it is Part 8, it means you probably won't have to stump up a whacking great issue fee, which is what you do often in lots of other areas of law. But fortunately, in Inheritance Act claims, you don't have to. That's quite important, because if you're not well off, it's going to be hard for you to bring a claim against an estate. The other thing to note is you may be afraid if you're bringing a claim, and I've done another vlog on this, and I go into these issues in greater detail, so look elsewhere for that. I'll link that vlog below, actually. Is that it's very likely that the legal costs of arguing the point will be paid out of the estate. Okay, not always, but it's common for that to happen. So I say to clients, in other areas of law, I'm like, be careful, you may end up with a cost liability. We're going to have to take out special insurance to protect you against having to pay your opponent's legal costs, because lawyers will do no win, no fee. So if your case is strong, you might not have to pay your own lawyer's legal costs, but you're going to have to pay your opponent's legal costs if you lose in other types of cases. But in Inheritance Act claims, it's more likely than not, in my view, that the estate, that the pot of money is going to be paying the legal fees, win or lose. Okay, so there it is. Any concluding remarks? Well, as I say, Illot, and Mitson is the landmark case in this area. That concerns an adult child. Okay, so don't be too constrained by that judgment. The Court of Appeal, which is a very high level court, went with the adult child, so one can't quite guarantee that the courts are going to, in future cases, always sort of side with the deceased and the deceased wishes, even if they've written a letter of wishes, even if they think that their will is copper bottomed and they've decided to cut out a child or a partner or someone that they don't like. You can't ultimately, like you could back in the good old days, you can't deliver judgments from beyond the grave at least 24-carat permanent judgments from beyond the grave as to who is and who is not going to enjoy some of the proceeds of your estate, and the yardstick will, in most cases, be a reasonable financial provision. Bye for now.